and she's an assistant professor in Alexander Decru. And she has 1 minute. And she has done preparation in law in international protection of human rights and an European Union course and seminars. And also she is a deputy member of the Senate of Alexandria University and representative member of Professors Council of Law School. And she is a present lawyer specialized in criminal law. And so now, yeah, I have done it.
Thank you very much, Shreya. What you have said to the participants, it is important that just to prove them that I have at least 20 years of experience in the human rights field, and I'll try to do my best to present them the European perspective on the human rights. Of course, I'm going to propose you the same ideas I'm presenting to my students, because currently I'm teaching several courses, master courses for Romanian students, and not only for Romanian students, because in my university we have a master in English destined to the students specialized in law or in political sciences. But regarding European perspective, I always, and I propose you the presentation in PowerPoint, because I'd like to be followed easily by all of you, no matter their background in human rights. For sure, my colleagues in the day before, the 2 days, the first 2 days of this summer school, presented you general issues related to substantive aspects of human rights or procedural aspects of this interesting field. I have to confess that I'm really passionate in this field, and in my activity with my students, I always emphasize the importance of practical aspects of human rights, not only theoretical ones. As well with my with the lawyers the young lawyers in Yash Bar, as well I'm discussing human rights issues. So I can follow the two approaches, the theoretical approach and the practical approach. But when we are discussing about European human rights system, we have to have in mind 3 important issues. We have to understand which are the main intergovernmental organizations established on European continent, and take into account these important issues, the intergovernmental organizations. We have to analyze 2 important aspects. On the one hand, we have to have in mind the legal instruments adopted and ratified by member states of a certain European intergovernmental organization, and the other part is destinated to procedural issues, and this is focused on mechanism for human rights guarantees. And of course, we are making references to the courts or to the committees or the commissions which are functioning in each intergovernmental organization on European level. But going further, we have to understand that to the European level, we have three intergovernment organizations. May I ask you if you know some things about one of these intergovernmental organizations? Because these three intergovernmental organizations are Council of Europe, is the first intergovernment organization founded after the World War II, and is focused on the protection of human rights and the rules is specialized for democracies. The European Union is the most recent intergovernmental organization founded on European level, because is reuniting some other European communities founded as well as Council of Europe after the World War II. And we have the third intergovernment organization, the Organization for Security and Cooperation in Europe. This organization, as I'm going to present you in the end of our meeting, is composed by the states not only from Europe, but from other continents. But coming back to my question, do you know something about Council of Europe, of European Union, or Organization for Security and Cooperation Europe? Just to have an interactive activity meeting today. I don't like to have only speeches, monologue speeches with my students. And I think it will be more challenging for you to have this kind of discussion. Fatma, please.
I'm actually an economics major. So about European Union, we had studied about it in the economy, international trade, that the European Union is responsible for conducting the free trade agreement, which is actually customs union in Europe. And along with UN and WTO, it manages the money inflow through trade in Europe. And the Brexit was actually from European Union.
So thank you very much, Ayat Fatma. What you mentioned underlines, in fact, the main character of the activity of European Union. So when we are saying European Union, we are not saying especially the human rights protection, but in the main treaties of European Union are provided rules which are focused on general protection of human rights. And we have the Article 6 of the Lisbon Treaty. This article is providing the fact that human rights are important for European Union, that they have to be respected by all the member states of this intergovernmental organization. As well, in paragraph 2, the treaty is making references to the main legal instruments specialized in human rights. One of these instruments is adopted by European Union is the Charter of Fundamental Rights, and the one is a special instrument adopted by Council of Europe, but is put in practice as well in European Union, and this is European Convention on Human Rights. So European Union Treaty, the Lisbon Treaty, is trying to make a connection between two European intergovernmental organizations, Council of Europe and European Union, in order to assure a common standard for human rights protection. As well, in this Article 6 of the Charter is provided the importance of the constitutions of the member states of European Union, and not only the whole constitution, but the provision of the constitutions specialized on human rights. So, in fact, if we make make a strong and keen analysis of this Article 6 of Lisbon Treaty, we can establish a certain hierarchy of the norms which are important for human rights protection to the European level. We have, firstly, the constitutional dispositions of each member state, because on these constitutions is established the standard of European Union protection of human rights. And then we have the convention, European Convention on Human Rights, adopted by Council of Europe, which was applied by European Union, because in the first instance, European Union didn't have a proper, suitable legal instrument. And then in 2000, European Union adopted its own legal instrument, the Charter of Fundamental Rights. I presented this way of approaching the human rights field because I think this can be an example for other intergovernmental organizations which don't have a certain level of European human rights protection. I know that in Asia you still don't have an organization specialized on human rights. This doesn't mean that you are not interested about this field, but definitely when we are talking about legal issues, we have to take in mind the political issues as well and political interests as well. But in my opinion, when I'm discussing with my students Asian perspective on human rights, I'm saying to my students that religious perspective has to be analyzed in function of principles which are protecting human rights provided by legal norms. Coming back to the European Union, I have to underline that this intergovernmental organization has provided in its fundamental treaty, current fundamental treaty, the Lisbon Treaty, a catalog of human rights, and this constitutes the second part of the treaty. If we have a general provision in the Lisbon Treaty and we have the second part which contain an entire catalog of human rights with rights specialized in civil rights, in political rights, economical rights, social rights and cultural rights, we can underline that definitely European Union desires to emphasize its contribution in guarantee human rights to the European level. But beyond these general sayings about European Union, we have to start our presentation with the Council of Europe. As I mentioned before, Council of Europe is the first European intergovernmental organization founded to European level in order to protect human rights after all the violations of human rights which happened during the Second World War. All the politicians to the European level have decided that moment that they have to be together and they have to do something in order to avoid another world war. So they created this organization, and this organization had the main focus on human rights protection. But to go further, we have to, as I proposed you in the beginning of our meeting, we have to be very clear which are the main legal instruments specialized in human rights adopted by this intergovernmental organization. And the main legal instruments are the European Convention on Human Rights, which contain a catalog of civil rights and political rights, and the social rights are provided in European Social Charter. Each of these legal instruments is checked by a certain organ which is functioning in Council of Europe, this intergovernmental organization. And always when we are discussing about European Convention on Human Rights, how is this instrument respected by the member states, we have a look on the case law of European Court of Human Rights. And when we analyzing how is respected the European Social Charter, we have in mind the activity of European Committee for Social Rights. As well, when we are discussing about Council of Europe, definitely we have to analyze the other conventions adopted to the Council of Europe level. And these conventions are developing human rights topics related to vulnerable groups as I say, the children rights, or the rights of minorities, or rights of certain persons which are in a vulnerable situation as detainees or refugees or migrants. As well, these conventions are related to some very sensitive situations, as the situation of being in custody of the national authorities, or some situations related to the biomedicine, or a situation of human traffic, or terrorism, or some other very important cases in which human rights have to be discussed. About European Convention on Human Rights, I mentioned on the slide. It was open for signature on 4th November 1950 and entered to force in September 1953. It's important that this European Convention is the first legal instrument with binding effects. Beside the Universal Declaration of Human Rights, if we are making a comparison between the Universal Declaration and the European Convention on Human Rights, we realize that the declaration was a source of inspiration for the ones who they wrote the European Convention. Of course, the other continents, they are respecting the same line imposed by Universal Declaration of Human Rights. From 1950, the convention has suffered several amendments. So currently we have 16 protocols to this convention. I mentioned these protocols. Some of the protocols are modifying the first part of the convention. The first part is related to the catalog of human rights, and the second part of the conventions is referring to the rules which are governing the functioning of the Court of Human Rights. But the main protocols I can say that are the Protocol 2. This Protocol 2 refers to the advisory opinion which can be provided by the court in accordance with the perspective of the court and the Committee of Ministers, which is an organ of the Council of Europe. Or I can mention the Protocol 6, which is abolishing the death penalty, and this is a very important issue. Or we have Protocol 12, which is introducing a general prohibition of the discrimination, and as well Protocol 13 concerning of abolition of the death penalty to all the circumstances. This is meaning during the war or during the peace times. The last two protocols entered to force very recently. The most recent protocol is Protocol 15, which is modifying the term in which a complaint before the court can be introduced, and is making shorter the term, is transforming the general term of 6 months into the term of 4 months. And this is very important to be known by the applicants and their lawyers. I know that discussing with my colleagues from the bar, Yash bar, they always are asking me to be very precise relating to this term when is entering into force this Protocol 15, because they want their complaints to be declared admissible by the court. As well, we have the Protocol 16, as you see on the slide. This protocol entered to force in August 2018. And why is important? Because the highest courts, national courts, can ask to the European Court to be provided some rules which can be applied to interpret the convention, European Convention on Human Rights, and to apply this European Convention to the human rights to the national level. Going further, we can, as I said before, if we are analyzing in very general feature the European Convention on Human Rights, we realize that in this convention we have only civil law, civil rights and political rights. This is important to be known because all the applicants to the court, European Court, they have to respect the competence ratione materie of this court, and they cannot introduce the complaint related to some other rights than the rights provided by the convention. It has to be always has to be identified in a certain some situations, some facts. They have to be identified the social values which are in the core of each right provided by the convention. This is the procedure I always suggest to all my students or to the young lawyers with whom I'm working, to study very well the convention and to understand in which situations can be discussed that a certain article or a certain right provided by the European Convention. Now, as you know for sure, the main civil rights are the right to life, the prohibition of the torture, the prohibition of the slavery or forced labor. These are the first three absolute rights, because if we want to finish the group of absolute rights, we have to mention as well the Article 7 of the Convention, no punishment without law, and the general rule specialized for criminal field to not have two trials for the same facts or crime committed by a certain person. So if we want to organize this catalog of rights provided by the European Convention on Human Rights, what I propose you is to have in mind this classification of rights between absolute rights, and these rights cannot suffer limitations, and the other rights, the rest of the rights provided by the convention and protocols of the convention, they can suffer some limitations, but only if these limitations are made in conformity with three very strict rules. And the first rule, the limitation has to be provided by a law. The meaning of law in the case law of European Court of Human Rights is not the same meaning as the one had in mind by national judges, because we have to understand that the law to the European level means not only the acts adopted by the national parliaments, but the administrative acts adopted by the governments or the decisions adopted by the courts. So the meaning of the law in the European level is more extensive than the meaning, the national meaning of the concept of law. The second rule, which has to be fulfilled by the limitation of a certain right, is to satisfy a certain legitimate interest. And in the convention are provided these rules, and it is important. These interests are public interests or private interests. Are public interests if we mention the national security or public security or public health or public morality, and has a private character when we are talking about the rights and the liberties of other persons than the applicant or a certain holder of a certain right. The third rule for the limitations is related to necessity in a democratic society. And what we have to understand through the concept democratic society, the European Court of Human Rights is proposing us some principles, 3 principles, in order to have a clear concept. And these principles are principle of plurality, the principle of tolerance, and the principle of being open to the situations in which has to be identified some violation of human rights or some necessity to protect the human rights in new situations in current society. In all these rules, the provision of the limitation in a certain law, the necessity that limitation to satisfy a public or a private interest, and the necessity to be in a democratic society have to be understood, taking into account another principle, is the principle of proportionality. This principle is very important to understand if the limitation really has to be done by the authorities, or this limitation is touching the substance of a certain right. And of course, in this situation, this case has to be solved, establishing the breaching of a certain right, the violation of a certain right. Good. So we have as well civil rights. As I said you before, the fourth absolute rights. We have some important procedural rights, as the right provided by Article 6, the right to a fair trial, or the right provided by Article 13, the right to an effective remedy. It's important as well, and the right of not be discriminated. And we have Article 14, and as you saw before, we have as well the Protocol 12 of the Convention, which is extending the criteria for eliminating discrimination in the current society. As well, we have political rights. The political rights are the ones related to the free elections, as well the freedom of assembly or freedom association. And we have some rights which can have a double legal nature. Because when we have a look on the protection of property, we can say that this right is an economical right, is not a civil right, but the reality which was existing in the moment when the convention was written and adopted was not facilitated the discussions on economical rights, because the World War II, it was a disaster for the all European states. You know very well that after this war, Europe was completely destroyed, because the main actions took place on this continent. So it was not in 1950 the moment to discuss about more economical protection than the one was absolute to be assured by the states in that special economical context. Okay, so we have some rights which have double character, economical, civil, or we have provided by the Protocol 1, Article 2, the right to education, this right can be considered a civil right, or as well can be considered a cultural right. Yes, so it is important that this catalog, first European catalog of human rights, was organized taking into account the needs, the fundamental needs for European society. On this basis was rebuilt the entire European society after this World War II. So even I said before that the convention and its protocols is focused on civil and political rights. We have to underline the directions of the case law of European Court of Human Rights, the current directions. And these directions are very open-minded because the judges of the court are discussing the facts and are interpreting the facts, not in the very strict light of the convention, but is underlining the importance of the principle of indivisibility of the rights. So this principle of indivisibility of human rights, in fact, is referring to the connection between the rights which are existing in the first two generations of human rights. I know that for sure most of you know that we have three generations of human rights. The first generation of human rights are the civil rights and political rights. The second generation is composed by the economical rights, cultural rights, and social rights. These two first generations are created firstly to the national level and are recognized only after the World War II to the international level. For this reason, we have distinct legal instruments to the regional level and to the international level. For sure, Antonietta told you yesterday about the two covenants of the rights, the International Covenant on the Civil Rights and Political Rights, and another covenant, International Covenant on economical, social, and cultural rights. In this division, we have as well to the Council of Europe level, because as I said before, we have two legal instruments. We have the European Convention on Human Rights focused on civil and political rights, and we have the European Social Charter, which is analyzing and proposing guarantees for social rights. But currently, the European Court is trying to put together the all generations of human rights, because we cannot understand a certain case without making connections between different dimensions of the human rights. And we have recently decisions of the European Court in which some rights are interpreted in a very extensive manner and related to the private life. We have to say that we have decisions which are formulating the right to a healthy environment. So we can say that when an applicant wants to write its application, he has to have a look on the conventions and its protocols, but as well he has to read the case law of the European Court of Human Rights in order to identify the indirect rights. We can, in French, we say rights en ricochet, Are rights which are interpreted currently from European Convention. And this example, the right to a healthy environment, is a right on ricochet, as I mentioned you before. As well, another very interesting situation in the case of European Court on Human Rights is how the court is solving the conflicts between human rights provided by the convention or between the rights provided by the convention and the rights provided by some other legal instruments adopted to the Council of Europe level. And we have a situation, the conflict between the right to have a house and the protection of property. And very recently, the court decided to offer satisfaction to the one who is asking the recognition of his right to have a house assured by national authorities. So, in fact, the convention and the protocol 1 of the convention is interpreting in a very modern manner. Okay, so we going further, we can say some words about the court, because this catalog was referring to the first part of the European Convention on Human Rights. Related to the European Court of Human Rights, we have to know that it began operating in 1959. We have a lot of judgments given by the judges of this court. We can say that is a very huge success for the individuals and for the Intergovernment Organization as well, for the Council of Europe. In the first instance, the European human rights system was composed by the two organs, and these organs were the European Court of Human Rights and the European Commission of Human Rights. The European Commission of Human Rights functioned only till 1998. And in its attribution, checking the admissibility of applications before the European system of human rights. May I ask somebody to switch off the microphones of the participants who are joining this meeting together with their relatives? Related, I'm trying to find a way to switch. May I ask the organizer to switch off the microphones of the participants, please? Okay. Concerning the jurisdiction of the European Court of Human Rights, what I can say is that the European Court of Human Rights has jurisdiction to decide the complaints, the application, as I said before. These applications can be introduced by individuals. And when I'm saying individuals, I'm referring to the person, the group of persons, or government organizations. Or these complaints can be introduced by states against some other states which are members of the Council of Europe. This is very important to be understood. We cannot have a complaint against some other states than the state members of Council of Europe. Otherwise, we are breaching the ratione personae competence of European Court of Human Rights. As well, European Court of Human Rights has advisory jurisdiction in accordance with the Protocol 16 of the Convention. The Court can offer advisory opinion on the questions of interpretation of the European Convention and its protocols. The structure of the court, we have 5 sections. From the administrative point of view, each section has a president, a vice president, and other 6 or 7 judges. Each member state has its own judge in the court. So currently, after Russian Federation left the Council of Europe, we have 46 judges in the European Court of Human Rights. The court is analyzing the cases referred to it in 4 judicial formations. The applications are analyzed by a single judge, and this judge is specialized to check the admissibility conditions, exigencies, and when it's obvious that the application is not admissible, is pronouncing a final decision on in that case. Another judicial formation is the committee composed by 3 judges, and these committees are acting in the cases, we are calling these cases repetitive cases. So the facts proposed to be analyzed to the judges are the facts which are analyzed before this in some other cases in which the court pronounced as a violation of the convention adopted to the European level. So the committee is checking the admissibility conditions and is analyzing the merits of the case. The third judicial formation is the one corresponded to the chamber, composed by 7 judges. And from my experience as a lawyer, I can say that when a lawyer is receiving a letter from the court related to the chamber, he can open a champagne because he has a huge success, a huge luck with this case, with his case. Generally, 90% of the complaints are rejected for not being in accordance with the criteria, admissibility criteria. So when we have a chamber, we know that the judges will refer to the merits for sure, without being a repetitive case. And we have the Grand Chamber, composed by 17 judges. This chamber can analyze a certain case in the first instance if the normal chamber is sending the case for a new interpretation of European Convention, or is appeal chamber when is analyzing the appeal against the decision made by the chamber of 7 judges. The proceedings before the court are primarily in reading. We have very rarely public hearings in very important cases. As I said before, we have in this procedure before the court two phases, two stages. The first stage, the admissibility check, and the second stage, the analysis of the merits. The admissibility check is made having in mind, first of all, the four types of the competence of the court. I mentioned you before the ratione materiae competence. This was meaning that the application has to contain a reference to a certain right provided by the convention or the protocols of this convention, or some rights which are identified by the judges of the European Court of Human Rights. We have the second type of competence, ratione personae, and I mentioned to you that the individuals can introduce this kind of application before the court, and we don't have some constraint related to no criteria to these individuals. So the kids, they can introduce a certain complaint before the court, or we have legal persons, or and they can introduce as well a complaint, or political parties, or we have some special groups created in order to protect a certain social value important for a certain community, as we have the case affaire linguistique Belge related to the parents that they wanted to have their kids' education in a certain language. As well, we have in mind that all the complaints have to be introduced only against states member of Council of Europe. Otherwise, the states are not obliged to respect the European Convention on Human Rights, so they cannot be forced by the European Court of Human Rights to respect the convention. We have the third type of the competence checked by the lawyers who are working for the court together with the judges. We have the competence ratione temporis. So the convention has to be adopted and ratified by the state took by the applicants in front of European Court of Human Rights, and of course the convention has to be enforced generally. And we have the fourth type of competence, the competence ratione loci. The violation of the convention has to happen on the territory and under the jurisdiction of the member states. But when we are saying jurisdiction, we have in mind not only the situation with the territory of the member states, but the situation when national authorities are working for their government outside of the territory of member states. And a specific case is the one related to the activity of army, national army, in some military operations outside of the territory of member states. And specific cases are the conflicts in Afghanistan or conflicts in Iraq, in which British soldiers or Dutch soldiers committed violations of the conventions when they took in custody Iraqi or Afghan nationals, or they didn't offer procedural guarantees to these detainees to have a fair trial of their cases. Yes, so after they are checking these these 4 types of competence, the lawyers are checking if the domestic remedies are exhausted, or the deadline, the 4th time deadline is fulfilled, or we are in some other situation when the deadline is broken. We have some other specific, situations when we have to analyze some other conditions. These are the individual's complaints, and a very controversial condition is the one related to the significant disadvantage suffered by the applicant in situation which Protocol 14 of the Convention is not matching the criteria for analyzing this significance. The judges of the court, European Court, have a very difficult job to identify if an applicant suffered or not this kind of disadvantage. What I can propose you is to watch a certain movie, but I don't think I can. Maybe if in the end of our meeting, I can propose you some links for you, and after after this course, you can watch the movie, which is presenting all the conditions which have to be fulfilled in order to satisfy the admissibility of the complaint before the European Court. Regarding to the merits of a complaint, generally these merits are analyzed by the chambers, which have reuniting the judges of a certain section of the court. The arguments are invoked by the applicant are sent to the government, the state which is brought before the European Court, and the government is proposing its arguments related to the violations to which the applicant is making references, and this exchange of arguments through the European Court is trying to solve, in fact, the case proposed by the applicant. That's why the court is always proposing to the parties to have a situation in which they can reach a solution without this case to be analyzed by the court. We have later a judgment on the merits of the case, and in the end, the court is offering a certain satisfaction to the applicants, beside the recognition of the violation of the convention in his case. The Committee of Ministers is the organ of Council of Europe responsible for enforcing the court's judgments. The friendly settlement I was making references before is the main solution proposed by the court, and some of the governments are preferring this kind of solution because they want to avoid the conviction of the state before this European Court of Human Rights. We have another situation in which the court has to pronounce a solution when a harm can produce irreparable, when a violation can produce an irreparable harm, a certain individual is asking to the court to establish this kind of measures in order to oblige the state which is violating the rights to do something to protect the applicants before the right is completely smashed by activity of the states or some other individuals. Regarding to the European Committee of Social Rights, as I said before, this is specialized on social rights. We have a different structure than the court. We have a committee composed by 15 independent and partial members. So we don't have judges. It's very important. They are analyzing the European Social Charter, and we have to know that the states which were ratifying the European Social Charter, they have to understand that they have to assure at least 5 following rights to the individuals. The right to earn a living in an occupation freely entered upon, or the right to freely associate national and international organizations in order to protect the economical social interests, the right to collectively bargain, the right to social security, and so on. This charter was changed and updated, and we have more rights which have to be satisfied by the governments which ratified the charter. The committee has a new way of analyzing and guarantee the social rights. The reporting system. When we are discussing about European Convention, we don't have this system. In fact, if we make a comparison between European human rights system and the international human rights system, we can notice that reporting system is a specific system for international human rights system and not for European. It's an exception. The obligation of the states to provide a national report in which they are describing how they are implementing a certain convention or certain right. We have 4 thematic groups when we are discussing about the European Social Charter: the employment, the health, the labor rights, and the children, families and migrants' rights. We have the procedure, the collective complaints procedure, because social rights are, they have a collective dimension, even they are individual rights, is established in the charter, this possibility to introduce this kind of collective complaints by the employers' organizations or some other organization related to the work environment. We have, as well as we saw to the European Court on Human Rights, some certain provisions of the admissibility procedure. We have some elements, compulsory elements for the formula which is introduced to the committee. As well, we have a solution which is taken in having in mind the merits of the complaint, and in this solution, final solution, are established if the charter is violated or not. I mentioned you before the situation of European Union, that we have an original legal instrument, the Charter of Fundamental Rights of the European Union. Why is original this instrument? It is the only one legal instrument specific for human rights field, which is providing together in the same legal instrument the rights belonging to the first two generations of human rights. So we have in the Charter civil rights, political rights, economical rights, social rights, and cultural rights. In other intergovernment organizations, we don't have such a legal instrument. This is very important to be understood by all of you. And when you have, you need a legal source, which for sure is providing the right you are looking for, go to the Charter of Fundamental Rights and you are going to find the right and the content of the right, the way are regulated the rights is original because beside the official text of the Charter, we have some other texts regarding the official explanations of the Charter. So always when you are looking to the Charter of Fundamental Rights of European Union, you have to read compulsory the official explanation of this charter, written by the same lawyers who were writing the charter. Which is the difference? Always I'm discussing with my students, which is the difference between European Convention on Human Rights and the Charter of Fundamental Rights of European Union, besides that they are legal instruments belonging to different intergovernment organizations. There are situations in which the member states of European Union, yes, are member states of Council of Europe. And in these situations, when we have a look of membership, appear the difficulty to choose between the two European organizations, which court to be announced relating to the violation of the human rights. The Court of Strasbourg belonging to Council of Europe, or the Court of Luxembourg belonging to the European Union. And this provision, which I'm going to read you in the following moments, is making this difference. The Charter of Fundamental Rights binds member states only when they are implementing European Union law. So this is the difference, which has to be very well understood by the applicants when they are deciding which European court are announcing related to the violation of his or her rights. Okay, so we have a very original legal instrument to the European Union level. And this instrument is analyzed together with some other legal provisions of European Union as directive or regulations or decisions of the European Union institutions. Because in the Charter we have a certain right provided, but all the details of the domain of application of that right can be provided in some decisions of the European Union Parliament or the Council of European Union procedure together with the European Union Parliament. Maybe I'm trying to move a little bit this in order to offer you possibility to watch a very short documentary related to the Charter of the European Union. I hope you are able to hear what they are going to say in this short documentary.
Since 2000, as a result, it's profound.
Excuse me, ma'am. Ranging from safeguarding to consumer.
Excuse me, ma'am.
The Charter Principle.
My voice is not audible.
You cannot hear anything?
Yes, ma'am.
So why, I don't know exactly what can I do, but anyway, I'm going to, I thought that you are hearing what they are saying related to the charter. I am going to offer you the link, yes, and you are going to watch this this documentary after the course. When we are talking about the charter, what you have to remember that this instrument is original because is proposing the principle of indivisibility of human rights. As I said before, the two first generations of human rights are provided together for the first time in a legal instrument. And another element of originality of this charter is the way the instrument is organized. I offered you the text of European Convention of Human Rights, and you noticed the structure of the convention was following the structure of the Universal Declaration of Human Rights. So there are some rights which are enumerated in function of the social value protected by that rights. Generally, the values which are considered absolute rights, the absolute values, and they are focusing the absolute rights are provided in the beginning of the catalog. And then we have the relative rights. But this charter is following in a way the concept, the traditional structure of the catalog of human rights, but is organizing these rights here in 6 chapters, as you saw on in the documentary. These chapters are the main social values protected by the European Union organization. And we have the dignity. For the first time, the dignity is provided as a right in a legal instrument. We have a provision related to the dignity in the Universal Declaration of Human Rights, but as a distinct right, for the first time, we have the dignity in the European Charter of Fundamental Rights, and is not only a specific right, but the dignity constitutes the first title of the Charter. We have the freedoms, the equality, the solidarity, the citizens' rights, and the justice. These are the 6 values important for the European Union when they are thinking about the human rights protection. In the chapter related to the dignity are included as I said before, the human dignity, the right to life, the right to integrity of a person, and the prohibition of the torture and human and degraded treatments and punishment, and the prohibition of slavery and forced labor. When I'm presenting to my students the charter, I emphasizing the novelty, the aspects which are very new in our current society, and are taken into account by the ones who are reading or writing this charter. And for the first time in a human rights legal instrument are provided aspects related to the medicine and biology. in order to protect the right to integrity of the person. We have some specific conventions in the field of biology and medicine, or in bioethics, adopted to the Council of European level or to the European Union level, or of course the United Nations, but in a legal instrument specific for human rights, only in the Charter of Fundamental Rights we have provided the prohibition of eugenic practices, the prohibition of the cloning the human rights, or the prohibition of traffic of human bodies. As well, for the first time in a catalog of human rights, we have a provision relating to the traffic of human beings. Yes, in the fifth, in Article 5th of the Charter, we have the general principle related to this right. So, if we make a very short analysis of this first title of the Charter, we have to understand that the dignity is the base of all the human rights provided in a certain catalog, in a legal instrument, and in the continuance of this ratio, this way of thinking of how we are organizing the human rights, we have the right to life, and we have the integrity, in function of which we have other three rights: the right to integrity, the prohibition of torture and human treatments, and prohibition of slavery and forced labor. The following title of the Charter is the most complex title of the Charter, because is putting together civil rights, political rights, economical rights, social rights, but they are organized in this way because all of them, they have in their substance the necessity to protect the freedoms. As you saw in the documentary, in the Charter we have provided the right to private life in 2 articles. The article which is traditionally guaranteeing the protection of the right to private life as in the European Convention on Human Rights, and the new article designated to the protection of the data, personal data. Again, I can say that for the first time, European Union is proving its engagement that they really want to protect human rights in a modern having a modern approach and current approach in accordance with the developments of technology. So the protection of personal rights is not provided not only in a certain European Union regulation or decision, but is provided in a fundamental treaty as the Lisbon Treaty, because I said you before, the Charter of Fundamental Rights is representing the second part of the Lisbon Treaty. We have some other civil rights, is the right to marry or to found a family. Or we have the freedom of thought and religion. We have the freedom of the expression, or the right to information, or the freedom of arts and of sciences is a new right as well. As I said before, when I referred to the protection of personal right, because this freedom of arts and sciences is adding more ideas and more principles to the right to education. If we are having a look to the content of freedom of arts and sciences, we can notice that for the first time in a legal instrument specific for human rights is provided the freedom of university. What this is important to know that we have freedom of expression in universities. Professors can present their proper approach on some certain, in law faculties, some legal aspects, and this has to be assured by all the universities, all the faculties. We have some social rights, as I said before, the right to engage in work or to choose an occupation, or the freedom to conduct a business. We have economical rights, the right to possession and property, or we have political rights as right to asylum or the protection of in the case of removal, expulsion, or extradition. So this second title is really a very complex and very rich in substance chapter of the charter. The third title of the charter is the one designated to the protection of the equality. We have some traditional legal principles which are regulating the equality before the law, the traditional principle of equality before the law, or we have principles related to the non-discrimination provided in some other legal instruments, as I said before, European Convention on Human Rights. And the first time in a legal instrument specific for human rights, we have some other provisions. The provisions related to the national minorities, and this is really huge success for the ones who are creating this European Union human rights protection system, to include in this catalog this very challengeful right, the rights of national minorities. And why is a real challenge? Because there are some states members of the European Union which are not recognizing the concept of national minorities, and this one of these states is France. They don't recognize the rights of national minorities. They don't recognize the concept of national minorities. For them, they are foreigners or French citizens. We have some other original rights for a catalog of human rights, in a general catalog of human rights, the rights of the child. We all know that the rights of the child are provided in United Nations instruments. We have the Convention of the Rights of the Child, UN Convention of Rights of the Child. I can say that Article 23 of the Charter of Fundamental Rights is inspired by this UN Convention, but is underlining the elements which have to be analyzed specifically for European Union member states. And one of these elements is the balance in having contacts of a child with both parents, and the situation when a parent is taking out of the country his or her child without the consent of the other parent. We have as well in the charter regulated the rights of old persons. These are original because we don't have too many to the international level some specific conventions and specific mechanism to guarantee the rights of this category of vulnerable persons. But it's important that the European Union understood to have this kind of provision in this general catalog of human rights, and as well inspired by another UN convention, the Convention on the Rights of Persons with Disabilities. We have Article 26 of the Charter of Fundamental Rights, which is regulating the main rights of this category of vulnerable persons. And as well, the main criteria for making distinctions between persons is took into account by the Charter. This criteria is the sexual differences between individuals. So the equality between men and women is as well provided by the Charter in Article 23. Another charter, another title of this charter is organized in function of another social value, the social value of solidarity. And for sure, in this title, we have social rights, yes, because they are regulating different aspects of how work environment, the right to work can be regulated. But in this charter, in this title, we have two new rights, and these rights are provided by Article 37, the environmental protection. As I said you in the beginning of the course, in the European Convention on Human Rights, we have provided the right to private life. And interpreting this right to private life, the judges from Strasbourg Court, they identified a new right, the right to a healthy environment. And this right, this indirect right to ricochet in the Council of Europe is a direct right in European Union human rights system. Yes, because we are making references to this Charter and Article the 37. And the 38 is originally providing the rights of consumers. Usually the rights of the consumers are provided in some other legal specific instruments, but the European Union wanted to have a very modern approach of all the situations in which can be identified human rights to be exercised by individuals. They are included in in this catalog, this consumer protection as well. We have the political rights, traditional political rights provided in citizens' rights in the Title 5 of the Charter. The right to vote or to stand as a candidate is provided in 2 articles, because the election can be organized to the European Union level or to national level. For this reason, we have 2 articles in this title related to this political right. We have another right, the right to good administration, which is an important right because is making a notification of activities of several agencies and the European Union institutions. The same nature related to the activity of European Union institution agencies is making the right to access to documents. The European Ombudsman is an important organ of European Union in order to assure the respect of human rights, because all the individuals which are not satisfied by the way they were treating related to their human rights by a certain institution or organ of the European Union can introduce a complaint before the European Ombudsman. As well, the right of to petition, depending on the organs established to the European level or to the national level, can be exercised. The freedom of movement is provided in the same section of political rights, and the diplomatic and consular protection as well. For the first time is a right provided specific in this general catalog of human rights. But the most interesting chapter always for my students is the one related to the justice. We have here provided the main procedural guarantees. The right to fair trial, and the right to an effective remedy. If we make a comparison between European Convention of Human Rights and the Charter for Fundamental Rights of European Union, we realize that it is a huge difference of reglementation. The European Convention of Human Rights is providing the right to a fair trial in Article 6, having in its contain general guarantees, and these general guarantees are referring to the independence, impartiality, and provision by law of a certain tribunal. Another general guarantee is referring to the controversy and the equality of arms of all the parties in a specific trial, no matter if this trial is civil trial or is a criminal trial. Another general guarantee provided by the first paragraph of Article 6 of European Convention is related to the publicity of the procedure and of the decisions pronounced by the judges of this tribunal, of a certain tribunal. And we have as well another general guarantee. This is referring to the delay, the period of time in which has to happen a certain trial, and this period of time has to be reasonable. So these four categories, four guarantees are considered general guarantees of the right to a fair trial. We have in the same Article 6 of European Convention of Council of Europe provided two specific guarantees. These specific guarantees are presumption of innocence and right to rise to defense. Yes, so in Council of Europe perspective, all these guarantees are put together in the same right. In European Union, these guarantees, general and specific for criminal trials, are put in different articles. Yes, and why they proceeded in this way? Because they wanted to offer an extensive protection of all the guarantees, the general guarantees and the specific guarantees for the criminal trials. The Article 47 of the Charter of Fundamental Rights provides a new element for the right to a fair trial. This new element is the right to be assisted by a lawyer, no matter is the type of the cause in which we are introducing a certain complaint before a court. So we have the right to a defense in civil trials and in criminal trials. Yes, this is the main distinction, because in the Council of Europe, a legal instrument, the right to defense is provided only for the defendant. So only for criminal trials, not for civil trials. Yes, I'm coming back and I'm saying again, we have the right to the defense. In Council of Europe is provided and assured only for the defendant in criminal trials, and in the European Union is extensively provided for the parties in civil trials, not only for the parties of criminal trials. So it's very important to understand why these general guarantees are specific guarantees are provided in different articles in order to be understood correctly by all the individuals which are holders of human rights. The other rights, the principle of legality or proportionality of criminal offenses and penalties, and the right to be tried or punished twice in the criminal proceedings for the same criminal offense, are the other absolute rights which are provided in the Convention of European Convention on Human Rights in Article 7 on the protocol for the Convention of Human Rights. The Court of Justice, the one which is assuring the check of the respect of the Charter of Fundamental Rights, is checking as well the Treaty of Lisbon, in which is included the Charter of Fundamental Rights, beginning with 2009. This court is composed by 27 judges and 11 general advocates. The procedure is, as well as we saw in European Court of Human Rights, organized in two stages, the written stage and the oral stage. If we are making a comparison between the procedure of these European courts, we can notice that the Court of Luxembourg, the Court of European Union, has these original elements, the conclusion of general advocate, which are very important for the judges who are pronouncing the final decision in a specific case. We have two ways of discussing human rights before the Court of Luxembourg. The first procedure is referring to the preliminary rulings, how it can be applied and interpreted the European Union legislation regarding the human rights standard. And we have a discussion about human rights in other direct actions, action for failure or to fulfill obligations assumed by each member states of European Union, or actions for annulment when a certain measure has to be adopted by the institution or body, agency of European Union is annulment, or some actions for failure of to act in order to assure the satisfaction of exercising the human rights. And we have some other actions of individuals, the appeals related to situation in which we can discuss about human rights. I'm not going to discuss anymore about special forms of the procedure, because these are detailed in the PowerPoint which I'm going to offer you after the course. And we reached the moment, the final intergovernmental organization, which is functioning to European level, Organization for Security and Cooperation in Europe, which has 57 participant states. They have equal importance to the intergovernmental organization level. There is a documentary proposed by this organization, but unfortunately, I'm trying to find a way to offer you the sound of this. Maybe I'm trying to move this link to find a way to share with audio. Share with sound. I found. Okay, so you have the sound now. And please confirm me that you have the sound. Do you hear it, something?
Yes, ma'am.
Yes,
Okay.
ma'am.
yes, ma'am.
Okay, perfectly.
With 57 participating states in Europe, Asia, and North America, the Organization for Security and Cooperation in Europe is the world's largest regional security organization. The OSCE is an inclusive forum for dialogue on security issues and a platform for joint action to improve the lives of individuals and communities throughout the OSCE area. The OSCE's approach to security is comprehensive, and its engagement covers many relevant areas, from hard security issues such as conflict prevention and arms control, to fostering economic development, ensuring the sustainable use of natural resources, and promoting full respect for human rights and fundamental freedoms. The OSCE traces its origins to the Conference on Security and Cooperation in Europe, which led to the signing of the Helsinki Final Act in 1975, a groundbreaking agreement that established 10 fundamental principles for governing relations between states, focusing on cooperation and the peaceful settlement of disputes. Today, the OSCE is an intergovernmental organization in which all 57 participating states work as equals. Decisions are taken by consensus on a politically binding basis. Each year, a different participating state chairs the organization, with that country's foreign minister serving as chairperson in office. A ministerial council meeting is held annually to review OSCE activities and provide overall direction, while ambassadors meet each week in Vienna at the Permanent Council and the Forum for Security Cooperation. The OSCE has several structures, each with its own area of competence and mandate. The OSCE Secretary-General acts as the representative of the chairperson in office and supports him or her in all activities aimed at advancing the goals of the OSCE. The Secretary-General is also the organization's chief administrative officer and heads the Secretariat based in Vienna, which directly supports the chairmanship. As a tool of conflict prevention, the High Commissioner on National Minorities, based in The Hague, uses quiet diplomacy and early action to seek resolution of ethnic tensions that might endanger peace, security, and stability. The representative on freedom of the media, based in Vienna, provides early warning on violations of freedom of expression and media freedom, and promotes full compliance with OSCE media freedom commitments. The Office for Democratic Institutions and Human Rights, based in Warsaw, promotes respect for human rights, fundamental freedoms, and the rule of law, strengthens democratic institutions, and promotes tolerance and non-discrimination, and acts as the OSCE contact point on Roma and Sinti issues. The Parliamentary Assembly brings together more than 300 lawmakers from the parliaments of OSCE participating states to promote interparliamentary dialogue and cooperation. Most of the OSCE's staff and resources are deployed in field operations that support their host countries in the implementation of their OSCE commitments, or, like the Special Monitoring Mission to Ukraine, are engaged in crisis management or conflict prevention activities. The OSCE helps to bridge differences and build trust. At no time in recent history has this mission been more vital for European security than it is today. In times of growing division within Europe and increasingly complex transnational and global threats and challenges, the OSCE remains a key regional platform for inclusive dialogue and joint action.
Okay, I proposed you this documentary because I think it's more relevant to see how the organization itself is seen its activities, and if we have to make a comparison between the three intergovernment organizations established to the European level, we have to notice that Organization for Security and Cooperation in Europe is more political organization than a legal organization with judiciary focused on the judiciary aspects. To be sincere, when we are discussing about human rights, we are talking about political interest as well, especially when we have this discussion to the international level. So in this third organization, European organization, we don't have a mechanism which assures the guarantee for human rights. They are trying to promote different types of human rights. They are focused on specific general human rights protection if we are taking into account the activity of the Office for Democratic Institutions and Human Rights based in Warsaw. Or we have two types of vulnerable categories of persons. Vulnerable category of professionals are the journalists, and they are in a certain way protected by the activity of this representative on freedom of media. And another category of vulnerable persons are the national minorities, which are protected by the High Commissioners on National Minorities based in The Hague. But properly, they are not doing anything then that are checking how the certain category of rights or certain category of holders of human rights are protected. More than political than diplomatical discussions are not possible to be done by these offices or representatives or commissioners. But for me, it's important to know that different intergovernment organizations in Europe are trying to protect human rights. In fact, they are trying to influence the mentality of the individuals in order to assure the protection of the human rights as a general interest in European society. So I think this is all. If you have questions, please, the floor is yours now. I am looking forward to see what are your interests about the topic I presented you today. If you have some specific question, please have the courage to ask that questions. Yes, Ayat Fatma. Sorry if I'm not pronouncing correctly your name.
No, ma'am, it's all right. It's Ayat Fatma. So I know it's a bit different difficult for non-Asian peoples to speak that name. That's fine. The question I had was regarding the admissibility that we were discussing for the court in European Council.
Okay.
You were talking about, I think you took some 4 French principal names when you were talking. I didn't get those 4 principal names. If you could just...
4 principles, I was referring to the competence. Type of the competence. As a lawyer or as a practitioner in legal field, you have to know that when an application is introduced before a certain authority, doesn't matter if this authority is national or international, that authority has to check if is competent to solutionate, to offer a solution for that complaint. Do you understand? So if the court, the European court has to check if it's competent to offer a solution for an application related to a certain right. And he has, this court has to check if the right provided in the complaint, in application, is provided in the convention. So I can give you an example. I offered you the content of the convention, and it's better to have the content in front of you. I have to share. So I'm sharing. Yes. Yes, we have a complaint. Let's imagine that we have a complaint introduced by an Indian. Yes, because an Indian can introduce before the European Court a complaint. In which case can introduce an Indian this kind of complaint before the European Court? When a European state, member of Council of Europe, is violating the rights of the Indian citizen. We have to imagine that the Indian citizen is on the territory of a European state, or this Indian citizen is under the control of national authorities of a state member of Council of Europe. Let's imagine that a state from Council of Europe is doing some activities through its national authorities in a territory where Indian citizens are living. Yes, these national authorities of European states, they have to respect the European Convention of Human Rights, even in regard with the Indian citizens, because the first article of the European Convention is specifying a general obligation for all the member states of the convention, all the states which are ratifying the convention. Yes, and in this article 1 is provided states must assure this to everyone on their territory or on territorial control by them, has the right to and the freedoms set out by the convention. So these ideas are included in the competence ratione loci. Ratione, it's not French. It is a Latin expression. Competence ratione loci. This is territorial loci. This means territorial. Yes, competence. Then I said so is where was happening the violation of the convention. Yes, this is the meaning of ratione loci, competence ratione loci. The second type of competence is ratione temporis. competence, temporal competence. Yes, competence, territorial competence. This means when we can introduce a complaint before European Court of Human Rights in order to be admissible that our complaint. So we have to have in mind two moments are important. One, the first moment is the European Convention to enter generally in force. And I told you that in 1953, the European Convention entered to force. So the violation has to happen after September 1973. And the second moment, the second time, very important for establishing the temporal competence of the European Court is the moment when the state brought by the individual, the holder of human rights in front of the European Court of Human Rights, ratified the convention. Because only in the moment of ratification, the state assumed obligations related to the convention, to respect the convention. Yes, this is the moment, these two moments are very important, and they have to be checked by the lawyers of the court. Otherwise, if a state, the state hasn't ratified the convention, that state is not obliged to fulfill the obligations provided by the European Convention. And the third type of competence, I told you that is ratione personae, and I can formulate in another way, personal competence. Yes, the personal competence is referring to the rights, the holders of the human rights. Who is the holder of human rights? And I told you the holders of human rights can be a natural person, yes, an individual, or can be a legal person, a firm, a certain social, commercial enterprise. They can introduce as well a complaint before the court, or can be a political party. Yes. There are no criteria to make differences between the ones who can introduce the complaint before the court. It's important that holders to be holders of the rights provided by the convention. And the fourth competence, I told you, is ratione personae. This means which right can be provided by the applicant in its application. And compulsory, this right has to be a right provided by the convention or by its protocols, or can be a right identified by the judges of European Court interpreting extensively the convention. So these four competencies, material competence, personal competence, temporal competence, and territorial competence. These are four competencies which are analyzed by all the authorities which can analyze if they have to do a certain activity or not when an individual is introducing an application before them.
Thank you so much, ma'am. Now it's much clear.
Okay. Tivari, Saksham Tivari, I think.
Ma'am, I want to ask a question. If we talk about the current scenario in the world, the biggest problem around the world and with European Union too is the tension between Ukraine and Russia. If we talk about the European Union, what's your opinion? The same will be dealt very nicely if done. And what is going wrong if some conventions or some treaties are violated?
So you asked, if I understood correctly, you asked something about the importance of the influence of European Union in this current conflict between the Russian Federation and Ukraine.
Yeah, right, ma'am.
Okay. What I can say you is that I am not very optimistic. Generally, I was not optimistic about European Union. I don't want to mention now which are my reasons. But what I can say that during this war, I realized the importance of European Union, and I'm very convinced that European Union, in a very united action between the member states which are affected primarily by this conflict, can do something or should have done something before the start of this conflict. But unfortunately, the European Union is not functioning, taking into account the equality principle. Yes, and we noticed that we don't have anymore a certain unity of views, even between France and Germany. When the Chancellor of Germany or the President of France had to have their discussions with Putin, President Putin, they had different meetings. It was not a common team, a common group, which had this kind of discussions with the Russian president. And for me, it was a huge disappointment because they were not focusing on the interests of Europe, and they were focusing on other national own interests. In my view, I think we had the success, a delegation composed by French president, by German chancellor, by Romanian, because we are in the border. I'm very close to the Ukrainian war. My town is very, very close to the border of Ukraine. So I have lived this conflict in a specific tension because we don't know in which moment we can become part of this conflict. Fortunately, we are out of conflict for the moment, and I hope this will be in the future. But this delegation, composed by French, by German chancellor, by Romanian foreign affairs minister, by Polish foreign affairs minister, and by Baltic states foreign affairs ministers, I think together they would have had another influence in their negotiation with the Russian president. But for the moment, I don't know if any party is open for negotiations. The things are really, they went in a very wrong direction, and I don't know which will be the solution, because all the politicians to the international level, they are acting using their ego. So when a person, especially a politician, is thinking about his ego, they cannot find a solution. I think maybe in several months they will have maybe different opinion because of some economical challenges, let's say challenges. And we don't know, in fact, behind of this conflict, what is happening. Definitely is not about, in my perspective, is not about Ukraine, but it is about what is going on to the international level. which are the two or the three important groups of states which have to lead and to establish the interests to the international level. I think this is all about. Until they will not satisfy the geopolitical influence to the international community level, they will not end this war. I hope that they will be realistic and they will stop the war, because innocent people are dying for huge political interests, and I think these deaths can be stopped if politicians are open to make compromises, both sides, for sure, both sides. Without compromises of both sides, we cannot end this war. And let's hope that this war will be located only in Ukrainian territory and not be extended to the neighbors as some other NATO member states. So European Union is very important. It can be considered a global actor now, but has to act as a united actor and not satisfying only the interests of certain member states.
Thank you, ma'am. I got my answer.
Okay, my pleasure. If there are some other questions, I was promising you to offer you the links, and I am going to do this till somebody else will ask another question. Stop sharing, and I have the chat. Let's find. I'm waiting. No, I have to choose everyone in the meeting, and I'll put all the links. The one with the Charter of European Union, the one with the International Organization, OSCE, and the one with the European Court of Human Rights, which is functioning to the level of Council of Europe. Okay, so what I can say, thank you very much for attending this class. I hope that you found some interesting information. Some of the information were very theoretical, some of them were more accessible for all of you. I don't know which is your educational background, how many were studying before human rights, or how many of you are in advanced stage of studying human rights. I wish you to have good luck, success in attending these summer course meetings. And what I can say, you please trust in the human rights, protect your human rights, and protect the human rights of the others. If only respecting the other persons, you are in fact protecting human rights. Always I'm presenting to my students that the key of human rights protection is the respect, the individual respect. So my invitation is made to you, is to respect yourself, because only if you are respecting yourself, you are respecting the others.
Thank you so much, ma'am. And it was an insightful session. And thank you so much to all the participants we changed the time for the session, and thank you for attending and managing in your schedule. So see you in the next session, which is tomorrow. Thank you once again.
Thank you. Namaste.